Are you confident that your business is 100% legally protected? Do you understand and do you have ownership in things like your trademark, corporation structure, copyrights, DBAs, all of those things? Well, in today's episode, I'm very excited to have one of my really good friends and personal attorney, Scott Reib from Reib Law. Scott Reib is a small business attorney that specializes in service-based businesses, and he is here today to give us tons of valuable information and some best practices that we can do to make sure that all this business that we're building is set up for success. So here we go. Welcome to Marketing Domination. All right, so I am so honored to have my good friend and attorney, Scott Reib, on here with us today. Scott, I'm very thankful for you. So thank you so much for taking the time to join me here today.
Oh, Sean, thanks a lot. It's going to be fun. We always have a good time together, and I learned as much from you as I possibly could help you.
So I want to start this off with laying a foundation of just some terminology, because I think that with a lot of the business owners I work with in the marketing realm, I know that they don't fully understand what some of these terms are. So I kind of want to rapid fire a quick thing so you can give us some overview of what these terms actually mean. Okay.
Okay.
The first one is, what is the difference? What is a trademark and a copyright, and what's the difference between those two terms?
Okay. Well, a trademark is an intellectual property designation. So it's the stuff that you create that represents usually a brand name, a logo. So you'll see Nike, Starbucks. Those are trademarked, and they will have a circle R next to them because they register them with the United States Patent and Trademark Office, which makes them really official. You actually get common law trademark rights, which means that the law has it built in that if you create it and you make this your mark and you use it in commerce, then you have some rights in that mark. So if you've used Marketing Domination in commerce long enough that it eventually you become Marketing Domination, everyone knows you as that, and for anyone else to use something similar would cause confusion in the marketplace, then you have some rights. Now, it's harder to enforce them because you haven't registered it, but you have some rights in that. Copyright is what you would use for songs, videos, blog posts, things that are recorded mediums, and then you would register those with the United States Copyright Office, and then no one could use those works without paying you a royalty or getting your permission. You also have common law rights for copyrights, but you can't enforce those rights at all until you registered them.
Okay, so you said the trademark is the little circle with the R, the copyright is that the little circle with the C, and then what is the little circle with the TM? Is that also a trademark?
Yeah, the TM is what you would, so if you haven't registered or you've applied and haven't got it back from them yet, then you would use the TM next to it to show the world you consider that to be your trademark.
Understood. Gotcha. So the R is like the official one, but the TM means it's either in process or like, hey, I'm just saying that this is mine.
Yep. And sometimes you'll see a circle S, which is for service mark, and that's for service, kind of a service related industry. Sometimes they'll use the circle S.
Okay, check. All right. So then next is a little bit overview of there's trademarks, and then there's also corporation structures. So there's like sole proprietor, there's LLC, there's S corps and stuff, and those are different, right?
Totally different. You need both. For me, it's kind of step 1A and 1B. 1A would be get your corporate entity because that gives you protection. So it separates your personal life from your business and gives you a liability wall. And then 1B would be making sure that whatever we've named our business, we actually can own that and dominate it. And the way you do that is you register that as a trademark with the USTPO. And that's where it starts getting tricky.
Okay. And then what is a DBA? Because is that separate from a trademark and your corporate structure and everything as well?
It's a separate designation, right? A DBA is doing business as. And so for example, the official name of my legal entity is the Reib Firm PLLC. Now we have a DBA, sometimes called an assumed name, that is Reib Law, because people kept asking me, what does the Reib Firm do? So I decided to get a little more specific. And so we became Reib Law. And that's a DBA. And you can also have a DBA if you're just a person. So when I started my law firm, I started it in a hurry. It wasn't a real planned thing. I left one firm, had to start one. So I started as the Reib firm, as just a DBA. I was a sole proprietor, and I had a DBA on file with the county. So that was how I started. Within a couple of months, I started moving forward to get that legal entity. But you have old sole proprietorship, and you become an LLC or corporation or whatever your choice of entity is.
Okay, awesome. So that's kind of the groundwork of these key terms, because now I kind of want to give some common scenarios that I've seen so you can kind of help talk this through. Is this my legal disclaimer? This podcast episode does not institute as legal advice, and this is just for entertainment purposes only. But this is what I want to see is so we have. There you go. This is my lawyer, not yours. So I see this all the time whenever we start to go to build a website or something like this for some of our clients. Is one, they are very confused on the differences between those terms. They have some, but not the others. They think because they have one, they get rights to all the others, but it doesn't really work that way. So now kind of explain, now that we know what those three things are, and you started talking about like the process step 1A and 1B and everything, to protect your business, what can you actually own? And what I want you to really hammer home, because people don't understand this, is that just because you own one doesn't mean you own the rest or are entitled to them.
Yeah, and let's throw one more thing in the mix. You've got URL or domain names, which is where you buy your real estate on the internet, and that is also different than an LLC name or a trademark, right?
Okay, so tell me the process here of what I can actually own, and what, if I own one, do I get rights to the others, and all of that?
Yeah, so the dominant one, the one that matters the most, is the trademark. The name you get from your state for your LLC doesn't really matter. They've approved you because nothing else in your state was, in their minds, confusingly similar. So they gave you that name. That doesn't mean that in the adjacent state, someone else doesn't have something very similar, or that someone already has a trademark for that name. They don't do that search. You have to do that search. You could own a domain name with, go to GoDaddy and buy your favorite domain name. Sean and I have lots of them. It's like every time we have an idea, you buy one. And so he's got that real estate, but that doesn't mean that you have that brand, because someone else may have already trademarked it or be using it as a common law trademark, and so they've got some rights in that. And so it's a really complicated thing, putting together a brand that you can own. And it's really important that you do that, because you don't want to get 10 years down the road and then go, okay, now I'm going to spend some money and trademark my brand. And then you find out that you've lost out because someone else in the middle of that time trademarked it. And so now they have rights to your brand, or someone else already had it and you just didn't do the diligence to find out. Does that make sense?
Yeah, it does. And I've got clients that I've worked with that, I mean, they're going to be 7-8 figure revenue generating companies. Yeah. And they were even missing the mark on this, because they're like, well, I own the domain name. My corporation is registered in, like, let's say the state of Oklahoma, state of Texas. I own the LLC, and I went to the bank and I even have the DBA as I'm doing it as this. So I'm good, right? But that's not true, right? Like the trademark, like you said, is the dominant one.
No, let me give you an example, and I'll change the names to protect the innocent. But let's say in the there's a client in the state of Texas that they're in a fairly large city. They were a plumbing company, and they had been operating for 5-6 years. And they went to get a permit, because you have to get permits to do that kind of plumbing work. And at the city, they issued the permit, and the permit went to another company, because there were two companies. There was Acme Plumbing Inc. and Acme Plumbing LLC. And how that happens, it shouldn't, but it did. And the wrong company got the permit. And so then they were aware that someone else was using a similar name. So the next thing they do, Bob's your uncle, they hire their lawyer and say, hey, send a cease and desist letter to Acme One. And so they get this letter saying you have 30 days to rebrand. They contact their business coach, which everyone should do. And their business coach says, you need a lawyer. And so they send them to me. I review the situation with the demand letter, go to the STPO, see what their rights are. And this company had been using the mark, the company sending the cease and desist letter for 20 plus years, and they had had the trademark for 8 years. So they had dominated that brand. They owned the brand. So there was really no way to challenge it. And so you if you wanted to fight about it, you could go spend, let's say, $50,000 in federal court fighting over carving out some rights for that name. And we advise the client to don't do that. Rebrand. It's let's find a brand that we know you can dominate. Let's get that trademarked, and you guys move forward instead of getting dragged through this fight in court. But the key to that was that the complaining company had 20 plus years of using that mark in commerce. Then they went forward and registered it, and so they had common law trademark rights, and then they stacked registration on top of that. And so with those two factors, they were pretty much, you couldn't defeat them. They owned it. So those two things, time being time at first to use, and then first to register, give you priority over other people. The URL domain ownership has nothing to do with it, other than it might prove you're using it in commerce, but it's not a factor of owning that brand. It's just you owned the real estate, and the state registration doesn't have an effect. It's, are you using it in commerce? And Sean, you've been through some of the trademark filings, and we have to file that, you have to show the websites where you're selling something in commerce, and it's really obvious that it's a real legitimate business. And they don't accept everything. It's got to be very specific. And they call it a specimens of use in commerce. And so you've got to be able to show all of that to get them to recognize your mark.
Okay, so I can own, pretty much anybody can get any DBA, any LLC, and any URL that they would want. That's real easy. But to actually own it and protect it, you need the trademark. Okay. Let's think the opposite situation now. Let's think I actually have gone through this process. I've done it right, and I own the trademark. But let's say, for example, the domain is not available. So let's say I own the trademark on, Acme Plumbing, but I go to GoDaddy now, and it's not available on GoDaddy. Since I own the trademark, is the LLC able to? I know that if they're using the name publicly, I could stop them. But what if I wanted to then get that domain? Is that something I could do?
If they've just parked it, there's not a whole lot you can do other than buy it. If they're using it in commerce in a similar business class as you are, then you would be able to get a cease and desist letter out, maybe do a restraining order and stop them from using it in commerce. And then probably at that point, they would be willing to let it go to not have to pay legal fees in a federal fight. But if they're just parked on it and not using it in commerce, there's not a whole lot you can do about it.
Yeah. So this might be a gray area type or type of a question, but like, let's say I own Acme Plumbing as my trademark. They own acmeplumbing.com, but whenever you go to that website, it is actually Bob's Plumbing. And the company is Bob's Plumbing, but they just wanted to tie up a bunch of URLs and maybe set up redirects and stuff like that. That they can technically do that, right?
Well, if the Acme Plumbing is showing up, so if you do a search on your favorite search engine, and in those lists, it shows that name, Acme, anywhere in that little search, that would still be a violation of your trademark. So
okay, gotcha.
Unless it's masked in a way that it never shows up on anything, then it wouldn't be infringing. But if it shows up anywhere in that little string, and there's ways to do it, I guess, where it wouldn't. But if they aren't careful, then they would be infringed.
Okay, gotcha. Okay, so knowing all of that, and we know now we need a trademark. We need our LLC for our corporation structure with LLC, S corp, whatever you want to go with. We need our domains for digital marketing world. And then do you have to have a DBA if your LLC is what you want your name to be? Do you have to, or is that just more so give you rights to use an additional name or a variation of the name just for like clarification's sake?
It's to use an additional name for clarification.
Okay,
And
gotcha.
in a lot of states, especially like in Texas, if you're a legal entity, then you don't file a DBA with, that's usually at the county level. You file an assumed name at the state level.
Okay, gotcha.
And
Okay, so
the reasoning
okay.
for that is so that when you do those searches for names for corporations, more names show up that they shouldn't issue.
Okay, understood. Okay, so let's say I've done all the right things. I've got all those things. So first off, just side note, it is very difficult in today's society because I've seen it with our companies, with our clients. You probably see it even more than us. It's difficult to truly be able to find a brand and something that you can own, especially if it has any type of common use names in it, right?
Yeah, I
How,
mean,
if
Solomon
that's
had
the
it right.
case, like, what do you recommend? Like variations of the name, or like how can, like, because it seems as if I've seen this for myself, for clients and stuff. How would you recommend people kind of think about it, creating brand names them and not just going with like a Bob's Plumbing or Acme Plumbing and stuff?
Yeah, yeah. So you got to be careful because a lot of people, we fall in love with a name while we're forming this company. We have some name that we fall in love with. So be careful not to do that. The more fanciful and unrelated the name is to what you're actually doing, the more likely you are to be able to get that through. The example of that is always, to me, is Apple. The trademark and logo for Apple computers is an apple. It has nothing to do with computing, with phones, with technology. It's an apple. And so because it's so unrelated, no one else there was almost zero chance anyone else was using it in these industries. So that one's very easy to put through and make that brand a representation of what you do. But generally what people do is try to find brands that describe, hey, this is a description of what we do. Marketing people will do that because they want it to be keyword rich. And then you start having problems because you're going to run into, everyone's trying to be keyword rich. And so you run into this string of, well, they have two of our words. And so it's a real problem. So you really need to be as creative as possible. Solomon says there's nothing new under the sun, and branding has showed me that he was right. It's very difficult. And so you've got to have a really open mind and try to think of something you could use to stand for your brand that has nothing to do with it. And then your job as a marketer for your business is to make that symbol represent your brand. Because remember, the
Kind of
symbol
like
isn't
I
the brand,
always,
it's a representation of the brand.
yeah, one of the, this proves it in an opposite way. One of the things I always tell clients is whenever they're coming up with like names for programs or products and stuff like that, I always tell them the P90X story. I was like, P90X is a stupid name, but it's made millions of dollars. But now I see after this, that's why they used it. It doesn't have anything to do with it. Like it's still somewhat descriptive of a 90-day exercise program, but it's unique. So nobody was going to own that mark. So that's why they were able to get that.
Yeah, and like the name of my coaching and
So
consulting company is Shatterproof Solutions. It has nothing to do with coaching.
yeah, it's not like legal, your legal coach or something like that. It's unique to you. Okay. So we live and breathe right now in the digital marketing world and everything. We've got all that stuff set up. We've done that stuff right now. We've gone to a web designer or a marketing agency, and we're starting to put some marketing collateral and everything out there. And this is honestly just a Sean question as well. We build websites for clients all the time. What documents do they need now to protect themselves legally and make sure they're not, leaving themselves out to any open liabilities? So I'm thinking of things like any contracts or agreements, like privacy policies, like website docs, like stuff like that. What do they need to protect themselves that way?
Yeah. So when you open up an online business for sure, or a website for your business, you need to have terms and conditions, of use. You need to have a privacy policy, and some of those things you need if you're going to run any types of advertisement that requires it. You and I are go high level guys, and if you're going to use the SMS messaging in that system, you have to have a privacy policy on your website, or they won't let you use it. So you have to have some of those things. I would also include a disclaimer so that you're narrowing down what you can be held responsible for on whatever you're offering. So those are your digital documents. And then then you go to what we're doing with our customers on a direct basis. And that's where you're going to talk about contracts. And you want to have a really solid contract in writing, and that can be digital, but it's a written agreement between you and your customer client that explains the obligations that you have to them and their obligations to you. You want to have independent contractor agreements if you're using people that aren't employees to do work, that are very clear what the relationship is, what duties they owe you, what you will not give them and what you won't do for them, and that's really clear. And then you want to have employee documentation. So if you're hiring people, you want a good onboarding system, offer letter, employment agreement, employee handbook. Those are some of the basic things you want to have. And then if you have sensitive information, which could include your customer database, you want to have a confidentiality agreement. You might want to have a non-solicitation agreement. Some states still allow non-competes, but those are getting pretty unpopular and even being challenged at the federal level. But those are the kind of things that you want to have on a regular basis if you're running a business. And those are all things that are part of our Access membership in the Shatterproof Vault.
Okay. One thought or question that I just had because of that is, at what point does it make sense, or there's probably give me the legal answer here, I guess, but at what point does it make sense to have those agreements in place? Most of the clients that we work for physical products, I don't think that you obviously need an agreement for that. You're buying a t-shirt, here's a t-shirt. But for service-based clients, at what point is there a certain level of price or value or certain exposures that they should do that? For example, do I need an agreement if I'm a dog walker versus do I need an agreement if I'm going in somebody's home and doing home cleaning? Do I need an agreement if I'm doing plumbing services or coaching and consulting? Is there a certain point where you need that and it makes sense, or no, every service that you provide, you need an agreement with somebody?
Yeah, I would say the default is you need an agreement. The dog walking, let's kind of go down that road. What if the leash they provide you breaks and their dog runs away, or their dog runs away and bites somebody? Are you responsible for that? Well, maybe, but if we have a contract that says clearly you're not responsible for whether the equipment that they give you to use for their dog breaks or malfunctions, you're not responsible for their dog's behavior. You want to have those kind of things in your contract so that you can't held responsible. And there's a clause in a contract called a limitation of liability, where you would say, I'm only liable to you for the amount that you've paid me, for instance. So if they're paying you $50 to walk their dog, the most they could sue you for is $50.
So it's more yes, you need it, but it's also more so even if you don't think you need it, it's why wouldn't you have that for a situation just like that?
Yeah, because it's gotten so easy because we have so many platforms that you can use digitally, where people just sign off on terms and conditions of hiring you on their tablet, their phone. It's not like you're handing them a 10-page document and they're having to flip through it, and it's just so much easier now. So to me, there's very little excuse not to have it. And a lot of those services, I would use an order form, and in that order form is my standard terms and conditions, and you have to scroll through it, check a box, and say I agree to that before I ever come do that service.
Yeah, that's good, because I think that whenever we're talking about building things out, sometimes for clients, they instantly flip to oh, then I'm gonna have to print off all these contracts and hand them to people. But yeah, in our digital world, it's easy just to have that little checkbox of terms and conditions and get yourself protected there. Now, moving on to further down the digital marketing world here, got all this stuff set up and talking more about social media and protecting yourself on social media. Give me some legal liability issues that can come up when it comes to creating content. And some of the things that I'm interested in is if I post something, do I actually own it? Now there's a big thing to where there's reaction videos to where you'll see I keep using plumbing business, but you'll see a plumber looking at a video of somebody doing a walk through their house, and he's reacting to that. If he changes it any and adds his reaction, does he actually own that content? If your customers are posting content online, do you automatically get access to it? Give me kind of the legal rundown on all things social media for businesses.
Yeah, so general rule on that is if you post that on a social media platform, you no longer own it. The social media platform now owns it. So if your customer posts something on there, if a competitor posts something on there, it would then be fair game for you to use it and comment on it, change it, modify it to suit your purposes. But if we're using, say, Facebook's the big dog, that you put it on there, they own it. So like a lot of us are doing free Facebook groups and putting content on there to attract people to our funnels. Well, all that content you put on there, you no longer own. So you better make sure it's something that you don't really want to charge, that you might want to charge for later, because people are going to have free access to it. And for that matter, Facebook could take it and start selling it.
Okay. Does that include, like, I don't know if you'd know this, but is it including like all social platforms? Like, let's say I have a digital course and I'm hosting the videos as like private videos on YouTube. Is that still the case? Because they're technically out there in the private world, even though I'm using it as a like hosting service, or what? Do you know the
I
rules
haven't
on that
reviewed
one?
Google's terms and conditions lately, but my recollection is that they don't take ownership of your IP like the other social
Okay.
media platforms do. I guess because they're owned by Google. But every other platform that I'm aware of, you're at risk if you post anything on there that you're losing your intellectual property rights. And that may be okay. It might be a fair exchange because of the exposure you're getting. It's just knowing's half the battle. So just know that when you post something there, you're giving it up. It's free, and you could still use it somewhere else and charge for it, but it's just you've given up some rights. I've not seen
What
it hurt
about like,
anyone.
so talking about that in intellectual property, what if I have a framework or a methodology that I have and I talk about it on social media? Once I talk about it, does that still make it open to where now anybody can like take that training style or that framework or something like that once I put it out on social media?
Well, if you haven't already, so that would be a reason to go ahead and register that framework. So like create that framework on like a PDF, and let's register that with the United States Copyright Office. So now you've copyrighted that. So then if you talk about it in public, it's already protected. If they were to
Gotcha.
take it and use it, we could then send them a letter saying, hey, that's registered copyrighted material. You can't use it. And they don't have a defense of it's public domain because you've used it on Facebook.
Some wise advice right there. Okay. The other thing that I've heard you talk about too is website assets and building out websites. So this is one thing that you educated me on, and we had to change how we do things. But explain a little bit about website assets and legally protecting against that and ownership.
Yeah, so yeah, this is a big one of my rules is don't use other people's intellectual property without permission. But a lot of us do it unintentionally. We'll hire a web design company or a webmaster to create a site for us, and they'll pull images together to make it look really good. And then we love it and we start using it, and then we find out 6 months later when we get a cease and desist letter saying we've infringed on some photographer's copyrights, that that image wasn't paid for. And so you want to make sure that whenever you have a contract, you want to have a contract with your web people, and that contract requires them to use only sources that would give you the rights to use it on your website, and that they can give you that, transfer that documentation to you, or that they're going to use it from a source you provide. Like lately, I've been using FreePic. I've used Dreamstime. There's different ones you can use, but just find something you can subscribe to. And so you know that if you use that image on social media, on websites, on funnels, on emails, that you have the basic rights to use it. You also should pay a little bit of attention to what rights those companies are giving you, because it's not like you can use it for everything. Like if you're going to download an image to use as a book cover, you can't. You would either have a different license than the one you would use just to do a social media post or a blog.
And you are, and that's one thing I don't think people realize, is you can't use the excuse of, oh, well, the web designer did it. Like, you're the business owner's responsible. It doesn't matter what the social media manager or content creator or website design, but the business owners are the one that's liable.
Yeah. You could build into the contract that they have to indemnify you. So when you get that demand letter and have to settle it for $2,000 per image, then you could go to them and say you owe us $2,000 per image. But the better way is just make sure there's nothing on your sites that you don't have permission to use that you can prove. There
Okay.
is
And
no
so, okay.
oops defense. You can't say it was an accident. And I'll say there's been occasion where someone, all they've cared about is just pull it down, but it's rare. Almost everyone wants money. There's a group of lawyers that's all they do. is copyright infringement. And so they've got bots that are going across the web looking for these photographs. They're all identifiable, and then they start sending out these letters, and it's just, it's easy money because they've got you, and you're going to pay them something, because no one wants to go to court and fight about something that you can't win. And so it's very lucrative for them. And the photographers have rights. You shouldn't be able to use their photos without them being compensated. It's just a lot of us have done it unwittingly and not trying to hurt anybody.
And wasn't it you that was also saying that there's also a group that's doing the same thing with accessibility and having the alt text and stuff on images too?
That's a new and upcoming cottage industry of lawyers that are doing that. And then there's also people that are disabled that are taking advantage of that to some extent, that they're looking for sites that don't have the alt text, that aren't usable, that don't meet those standards, and then they are taking that. They've got to go to lawyer, and then they're taking that to them and getting a piece of the action.
Now, so what about on the, I guess this is another confusion point for me, and then I've had it for clients too. What if you take the image, but is there a certain point where if you take it and you change it, then you can have access to it, or no? Like, let's say there's this beautiful background picture that was not a royalty-free image, and I take it, but then I drop it in Photoshop and I add some stuff on top of it and my logo and maybe like some filters and stuff, and I change it up. Now can I use it, or no, because it was a modification of something that was protected?
Yeah, you're getting into some pretty advanced stuff there. That would be considered a derivative work and might have some copyright protection of its own, but generally the underlying work would still be entitled to some sort of royalty for it. So an example of that would be if you're writing a song and you just take someone else's melody and then put all new words on it. It's not a new song. It's just new words. And so you'd have to compensate them for the use of their melody. Now, if you take a bar of their, one bar or one measure of their song and mix it into what you're doing, that's kind of a fair use, and no one complains about it. But when you take the whole thing, then you've got a problem, and there's a lot of litigation about that stuff, where especially in the music industry.
And there's one thing that I've noticed here lately, because we use Canva sometimes just for like quick royalty-free image. We have the Canva Pro account and all of that stuff, but even Canva now, they don't allow you to just export images anymore. You have to do some type of change to it in order to actually export it down to your computer. And like, even if it's just like you add one little thing to it, they won't let you just pull off images anymore. You have to tweak it and modify it a little bit in order to download the images, because I'm assuming there was some type of lawsuit that happened there where they didn't have access to that or something. In a while.
Yeah, that's
it's new. It's just happened to me in the past month, because I was just pulling some images to like throw in a template, and yeah, it stopped me from that. So
spent way too much time on
now. Canva. Yeah. with staying on the last kind of question here on social media, let's say there's certain industries that it matters for more. I would assume yours. I would assume like the financial industry. For sure, I know with Courtney and in our medical practice, the medical industry. What can you do, or should you do, if you are if you're talking about your industry online? So if like Courtney, who has the medical practice, my wife, if she's giving some like health tips, and then how can she protect herself? Are you even giving like legal advice or legal tips and stuff? Is there anything that you need to do to protect yourself from somebody like coming after you for that? Or is it known like when it's on social media, it's entertainment only?
Yeah, they should know that. There's definitely some gray area there, and there's some risk that we all take when we go online as professionals and talk about things that are advice-like, because someone could take and run with it. The disclaimer we did at the first of the show is kind of the way I generally handle it, is that I'm a lawyer, not your lawyer. And you can put disclaimers even in your at the top of your pages on Facebook, Instagram, those sort of things. And then you just need to follow your industry standards. But a lot of us that are active marketers are really going with more of a forgiveness is easier than permission type approach, and
Yeah.
we're just marketing. And if we mess up, then we deal with it, because it's too costly. It slows you down too much to do everything perfectly by the book, as far as marketing regulations for medical, financial, legal. Financial seems to be the worst. Those guys have it really rough. They can't do almost anything without getting approved, or they're going to lose their license. Now, whether that's really true or not, or they just got them all scared to death, I don't know. But when I've worked with those kind of people, even because there's some stuff I'd like to do together sometimes, and they're like, we can't do that. I'm like, oh, come on, no one's really going to care. But apparently someone does. So I think it's really
Well,
kind of what's your risk level, your risk tolerance, what are you comfortable with, what do you have time to put together as far as a disclaimer, and then how much disclaimer or language can you do without hurting your message? Because if the marketing message gets destroyed, it's pointless.
and like even more on the financial sector, like we have several clients that are in that, whether it be some type of like investment firms or like financial planners and stuff like that. And even us, whenever we go to send out like email marketing and stuff for them, we have to run everything through this like spam checker, because if it's in the financial industry, anything that has any type of like monetary promise or even like possibility, we have to remove that from all marketing, or if not, it gets instantly flagged and Google won't even receive it. Like they're super, super strict.
Yeah.
And
so I would
okay,
say
so
you need to know your industry, and don't rely on marketing people to know the parameters, right? Because marketing people's job is to get leads into your business, not to comply with whatever your standards are. So make sure it's your job to protect yourself, not the marketing guys.
Yes, get a Scott and get a Sean. Don't trust just a Sean. I'm going to do whatever it takes to get the business. Thankfully, I've got a good relationship with you to where I just learn this stuff, and like the clients will ask for things. I'm like, I'm not a lawyer, but I'll tell you that mine would tell me I can't do that. So you talk to your lawyer, and if he tells you can do it, I'll do it. But I'm not going to do that. So thinking about that on that note is, you've done this for such a long time. You've worked with so many hundreds, if not thousands of small business owners. What is some of the most common places where you see that they're leaving themselves open and exposed to kind of almost like low-hanging fruit, easy fixes? Like it's not necessarily like this big deal, but it's this little thing that very similar to our faith, where it's the little foothold that the devil can get to just ruin everything. Like, what do you see in that with some of these businesses?
Yeah, and you've really walked right through them, Sean. They don't own their brand because they haven't taken the time to do it. They aren't using written contracts or agreements, and they're using other people. They're not being careful about how they're using intellectual property, and they get themselves in trouble. Those three things are super common things that come through our door, and they're really easy to fix. I say easy. The branding part takes time. But once we figure out what it is we're going to protect, doing it's not rocket science. But those are the three big things that we see over and over again that entrepreneurs aren't doing. And so it's one of my favorite books is The E-Myth Revisited, and Gerber talks about the seizure that we have, the entrepreneurial seizure when we start these businesses, and we get busy being busy, and we skip over steps that create these problems. It's not that we intended to do it wrong. We just got busy and we wanted to get that money in the door. And so we didn't do the contract. We did a handshake. I mean, I had that come in today, that someone's not being paid for work they did, and they want to send out a demand letter. And I'm like, send me the written agreement. And they're like, oh. The guy was older and was having trouble with the technology. And so he didn't sign, and we did the work anyway. Don't do that. You got to get something signed. If you have to print paper, get something signed. The fourth thing I'll throw in there is stay in your lane. Figure out what services you're going to provide, and don't jump out and offer something new just because there's money there. If you're going to offer something new, do the research, do the work, then go to market with it. Don't take it just because someone asks you if you can do it. It's akin to driving down the highway and changing lanes without looking. you're going to get smacked. And so stay in your lane and you'll avoid a lot of legal problems. But once you venture into something that seems as adjacent to what we do, there's going to be something you didn't understand about it because you hadn't taken the time to figure it out yet. And that will be the one thing that bites you. And then your pristine image is gone because of some project you did to make $10,000 now cost you $100,000 because you messed it up.
Yeah. So let's say I've listened to this and maybe I'm getting ready to start my business, or I've been in business for 10 plus years. And I'm like, I don't have some of this stuff.
Yeah.
I want you to talk about how you do small business law differently. Because most people, if they're thinking about this, they're probably right now juggling like, okay, I know I need to do this stuff, but I know lawyers are super expensive. So it's going to be, tens of thousands of dollars and hundreds of hours of legal fees to get this solved and these problems set up for me. Talk to them and explain to everybody what I love is the access plan and what you guys do with your legal services and how it's different than most other attorneys.
Yeah. So 12 years ago, I discovered I had a problem, right? I had repeat business. Small business owners were coming to me with the same problem over and over again. And it's like, why aren't you coming to me and asking for the contract before you do the deal? Why don't you have me review the contract before you do the deal? And it came down to they don't like how lawyers bill. Lawyers traditionally bill by the hour, really by the minute. And so they think of a lawyer and they think of money flying out of their pocket. So they would call their mom, Google it, do anything rather than call me. So I hired a business coach and we created what is now called the Access Plan. With my vision was for an on-demand type of system where people like me can ask any question they want to their lawyer, can have contracts reviewed, have branding discussions, make sure that they're keeping their business between the legal lines in an affordable way. And so we created a subscription, and there's 4 levels to access. The way we've divided it up is by revenue, but we don't ever look at your books. But if you're a startup business, then you're at our launch level, and that would be $0 to $250,000. It starts at $425 a month, and you get your LLC structure, what we call your shatterproof enterprise structure, designed, and we'll build it out if you're ready. And then you get your contract, your main contract done. You have monthly calls with your legal coach, which is me. And then we do SOS calls. So when you're sitting in a meeting and everything falls apart and you're like, what do I do? You have text, email, and phone access to your legal team for $425 a month. And then as you grow, we go up the scale and we end up at the top level at Guardian, where we're then talking about succession planning, legacy planning, making sure we have estate plans created. And that's where you're approaching a turnkey business and you're acting more as the owner of the business and not wearing all the hats anymore.
Yeah. And I don't think I want everyone to realize the value of that. So this isn't just like a legal Zoom where you're just going to be talking to some AI bot. Here's some recommended help articles about your legal issue. Like, you get full access to Reib Law and the Reib Law team there, almost like pretty much like it's on demand for fractions of the cost of what they would, like a normal attorney would charge just for their hourly fee.
Yeah, lawyers with my experience level are $500 to $600 an hour right now. And so for less than an hour of my time, you get access to the team for all those things, right? We've worked hard to figure out how to scale this in a way that gives access to the little guy so that you're not locked out of this game. Because every Fortune 500 company has lawyers out the kazoo, right? They can ask questions all they want. You guys have the same problems as they do, have been locked out of it. And so we've fixed that. Yeah, you still got to pay, but we're talking about less than $5,000 a year to know you've got a lawyer on call, that your entity structure is intact and will protect you, that you have legal documents in place that are going to minimize problems. And if you get into a problem, you've got someone on speed dial that can try to help you resolve it before it goes to litigation. To me, it should be a no-brainer that you need that. And there are other lawyers across the nation that do some similar things. Most of them are doing it at a high monthly ticket. We've kept it down purposely because I like to work with small business owners, especially service professionals. But that's how we do it. It's been a 12-year overnight success. We've got a lot of companies in the program now, and we're having a fun time doing it. I get to work with people like Sean every day. But like I said, we're doing monthly calls. It's like, we want you to use this service. And our job on that call is to find things we can do to support you within your plan.
Yeah, in marketing, we talk all the time about a no-brainer offer. Like it's a no-brainer offer. So let's say I've heard all this, and I'm like, man, I want to get connected with Scott. Where do people need to go to connect with you, hear more about the Access plan and everything that you have going on?
Yeah, go to reiblaw.com/access. If you'll go to that page, there's a nice little video at the top that explains a little more about the plans. And as you scroll down, you'll see the 4 levels, and you just figure out where you think you fit, hit the button, and it will put you on my calendar. And then I'll ask you a bunch of questions, figure out what your business is doing, and you'll get a feel for us. And if it's a fit, then you'll sign our digital agreement and become an Access member.
So we'll make sure that's down in the description and all things, reiblaw.com/access. And then you have a podcast and everything as well. Is there a place where if people just want to get connected with you and learn more about what you do? We've got an amazing book. I know.
Yep. We got the book. Sean's grabbing his.
I was going to say, I just redid my bookcase. You got to get the book. The Shatterproof Entrepreneur, Building an Unbreakable Business Legacy. Where can people get the book? Where can people get connected with you, whether it be on social or the podcast? Give us all that stuff.
Yeah, go to Amazon.com and get the book. It's $9.99. We're not trying to make a bunch of money with it. I want you to learn the 6 Shatterproof phases so that you can have a better business. We're working on a workbook that will be going live soon. Got a video course that's going to be created in the next month. And then, one of the best places to find me is on Instagram at the Scott Reib. And we're releasing legal tips and podcast episodes almost daily. And if there's something that you want to know, go on at the Scott Reib and send me a message and ask the question, and I might even answer it on the podcast.
Awesome. Well, Mr. Scott Reib, thank you so much, brother. Amazing man of God, amazing husband, father, awesome lawyer, and even better friend. So I'm honored to have you in my life, man. And thank you so much for taking the time to come hang out with me.
Sean, it's been awesome. Thanks for having me.
I hope you guys took tons of value away from that episode and you take Scott Reib up on that offer. Go to his website, check it out, sign up for a call with him, because I truly believe that too many small business owners are leaving themselves open to vulnerabilities that you don't even think of. So make sure you guys sign up for that call with him. Also, if you want to see where you're open up to on marketing vulnerabilities, go to SeanGarner.co/marketing report and take your free marketing assessment. On that, what we're going to do is we are going to do a deep dive inside of your marketing and show you some blind spots you have in your marketing, some things that you can do to improve that so you stand out on the line. Thanks so much for watching, guys. Have an awesome day.